universities have come out in opposition to the manager's amendment, and I'm sure we'll have a debate about the major cybersecurity concerns, but I would like to submit to the record the column written by Stuart Baker, the former Assistant Secretary for Policy at DHS and the former General Counsel at the NSA, opposing the manager's amendment and indicating that it would still do great damage to Internet security by putting obstacles in the way of DNSSEC, the protocol being designed to limit Internet crime.
Okay.
So bottom line, we do need copyright enforcement, but there's a better way to do it without the collateral damage to cybersecurity, innovation, commerce, and the First Amendment that the manager's amendment poses. And I thank the chairman for recognizing me.
Okay.
And yield
And
back.
without objection, those documents will be made a part of the record.
Mr. Chairman.
The gentleman from Wisconsin, Mr. Sinchberg.
Mr. Chairman, I move to strike the last word.
The gentleman is recognized for 5 minutes.
Mr. Chairman, as this bill and the manager's amendment have been introduced, I have kept my ears open, my eyes open, and my mouth shut, listening to what's in both the bill and the amendment and what its consequences will be for the Internet as well as its effectiveness. Now is the time for me to open my mouth. And I don't think that this bill will be effective. There are constitutional and national security issues involved, and unless the bill is fixed up, I will vote against it on final passage, and here's why. First of all, the national security issues have already been brought up. I am concerned that when we had the hearing on this bill, as far as the DNSSEC provisions were concerned, none of the 6 witnesses were able to address this issue. And I think that simply for that reason alone, this bill is not ready for prime time, because I don't think that we should be doing anything here that can potentially infringe upon national security, because international terrorists and crooks have now used the Internet as their primary means of communication. Now, I think the real problem is that the block and track issues, or block and redirect issues, that are contained in the manager's amendment is exactly what crooks are doing to bank customers. And if the bill with the amendment becomes law, the security system will not be able to tell the difference between sites that have been blocked by law and those that have been sabotaged by hackers. And indeed, it's hard to imagine crooks redirecting users that say, you are directed here because the site you asked for has violated copyright. And at the same time, that action has the opportunity to plant malware into the user's computer. And I can just see what people would think about us and not doing this right if the malware ends up showing in the computer and somebody's got to spend a lot of money or buy a new computer to fix the problem up. I'm also concerned about the First Amendment impact on this. The key provision of this bill gives copyright owners the power to stop online advertisers and credit card processors from doing business with the website merely by filing a unilateral notice that the site is dedicated to the theft of U.S. property, even though there's been no judicial determination of that fact. And the immunity provisions in this bill create an overwhelming incentive for advertisers and payment processors to comply with such a request immediately upon receipt. The Court has always treated such cutoffs from revenue from speech as a suppression of that speech, and the silencing of expression in the absence of a judicial review is classic prior restraint prohibited by the First Amendment. And I have to give some credit to a law professor whom I rarely agree with, Lawrence Tribe, for making that observation, but I believe that Mr. Tribe has got it right now. Now, finally, I'm concerned about the effectiveness of this piece of legislation. And this is similar to the debates that we've had in the committee over the past decade in attempting to stop Indian tribes from shipping untaxed cigarettes around the country in order to evade state and federal taxes that are due and owing by the end user of these products, as well as attempting to deal with other issues. By attempting to use judicial process rather than going exclusively toward following the money until maybe it's too late, I think we may very well have passed an ineffective bill that really doesn't deal with the issue. The gentlewoman from California, Ms. Lundgren, has said we don't go after the Postal Service or UPS. Lofgren, I'm sorry. You might hear something about the same from the gentleman from California, Mr. Lundgren. But we don't go after the Postal Service or UPS when something is illegally shipped through that means of transportation. I don't think we should treat the Internet differently. I'd hope that the Chair would reflect on these observations and maybe realize that a further fix-up is necessary and yield back.
Thank you, Mr. Sensenbrenner. The gentleman from California, Mr. Berman, who has been a real leader in writing this bill, is recognized.
Without any ownership rights implicated. I move to strike the alert, Mr. Chairman. Thank you for recognizing me, and I just want to respond to a few points I've heard primarily from my friend and colleague from California, Ms. Lofgren. Nowhere in her comments analogizing the ability to go after illegal activity on the Internet the same way we do in the world that the ranking member of the subcommittee, Mr. Watt, talked about in the brick-and-mortar world, did she even pay fleeting reference to the absence of our jurisdiction to go after foreign-based rogue websites at the source. She talked about going at the source, but she never acknowledged the jurisdictional limitations of going at the source. That's not true in the brick-and-mortar world that Mr. Watt referred to. But the thing that most bothers me about this comment is the equating of life in the United States after a bill like this were to pass with what China or Iran or other countries are doing with respect to suppression of Internet communication in their countries. That's nonsense. The focus here, there's a reason. We're not concerned about what China or Iran is doing because their efforts are designed to protect the consumers of their countries against counterfeit pharmaceuticals. They're not going after the people of their country because they're utilizing stolen property. They're going after what those governments are doing because they want to suppress speech, dissent, political activities which aren't simply embedded in our First Amendment rights, but are recognized as universal human rights through all kinds of treaties that those countries are signatories to. There's a big difference between regulating commercial activity designed to deceive the consumer or violate the ownership rights of a particular piece of property and seeking to suppress political conduct, political speech, dissent. The Secretary of State specifically said in a letter to me, which has been distributed, that there is no inconsistency whatsoever in aggressively pursuing a foreign policy agenda that seeks to get those countries, those governments, to stop their conduct which violates the universal rights that we all recognize and that all countries have signed on to, or nearly all countries, and particularly countries like China and Iran, and what they're doing in practice, and an effective and aggressive effort to stop digital theft. To lump those together is so funny, particularly coming from a side of the aisle that has always believed that consumer protection and efforts to stop fraud and counterfeit activities is a legitimate regulatory goal of the government and does not trample on First Amendment rights, and never has, and courts do not have not concluded that it has. This is just transferring that logic of sensible regulation and remedies against efforts to deceive consumers or steal property to the Internet world. And I don't think people should buy onto the argument that by our moving ahead with this legislation, we are in any fashion whatsoever removing our standing to aggressively pursue efforts to stop governments from suppressing fundamental human rights in their countries.
Would the
I yield
gentleman
back
yield?
to balance.
Would the gentleman yield?
I'm happy to yield. Yes.
We will have a longer debate on this. I appreciate the gentleman from yielding. The point I was trying to make in my comments is that this is the beginning of the balkanization of the Internet. We have one Internet today that has standards that are internationally accepted. If we engage in this diversion scheme, which is exactly the same technologically,
the gentleman's
as what
time has expired.
I would ask an additional 20 seconds.
Well, could we make it a minute so I could respond to the response?
Without objection, the gentleman from California is recognized for an additional minute.
The technology is the same, and it's going to lead to a balkanization of the Internet that will facilitate, I'm not going to suggest that enforcement of a civil action is the same as oppression by China. It is not. But the technological road this is leading us down is a serious one, and I also think that I just wanted to, I don't want to abuse my time, but I wanted to clarify my point, and I thank the gentleman.
May I reclaim your time and ask for 20 additional seconds? In one sense, we've gone down that road. What do we do about sites that are dominated by child pornography, by efforts to stop spam, to efforts to stop malware? The notion that this is some totally new concept put forth in this bill just isn't true in terms of what has already gone on and which we have by consensus supported in this body. I yield back, Mr. Chairman.
Gentleman's time is expired. Thank you, Mr. Berman. The gentleman from Utah, Mr. Chaffetz, is recognized.
Thank you, Chairman. And I have the greatest respect for you and for the Ranking Member Conyers. I do appreciate the manager's amendment. I do think it is moving. It is certainly better. There is clearly a problem. I understand that there is a problem, but I worry that this is the wrong remedy. I was trying to think of a way to try to describe my concerns with this bill, but basically, we're going to do surgery on the Internet, and we haven't had a doctor in the room tell us how we're going to change these organs. We're basically going to reconfigure the Internet and how it's going to work without bringing in the nerds, without bringing in the doctors. And again, I worry that we did not take the time to have a hearing to truly understand what it is we're doing. And to my colleagues, I would say, if you don't know what DNSSEC is, you don't know what you're doing. And so my concern is that there is a problem, but this is not necessarily the right remedy. Now, when we have, for instance, Sandia National Labs say that, quote, would negatively impact U.S. and global cybersecurity and Internet functionality, I would hope that would get everybody pause to say, maybe we ought to ask some nerds what this thing really does. Because I doubt that there's anybody in the room, except maybe Jared Polis and Ms. Lovgren and certainly Darrell Issa, that can tell you how this is going to work. Or not. Exactly. Or not. So I think we're going exceptionally fast. There is a problem. Let's take our time. Let's do it right. There is a problem, but let's bring the nerds in and get this right. There is a reason why time after time, Mr. Chairman, Sandia, National Labs, and other experts. I want to read one other quote from a paper here by some real experts. It says, as experts in DNS, implementers of the code running 80% of the world's DNS infrastructure, and as the co-authors of many of the core protocols for DNS and DNSSEC, we must inform that there are no protocol signals a resolver can send to a user to address the scenarios in SOPA and PIPA. So how can you vote or support a bill that is going to radically change how this thing works, that has such dramatic impact on the Internet? And I appreciate the discussion today. Look forward to a vigorous debate on the amendments. And again, I have the greatest respect for the chairman and the ranking member, but this is moving way too fast. This is not the right bill in the right form.
Would the gentleman yield?
Yes.
I thank the gentleman. You give me more credit than I deserve, but nerd is something that I'm proud to be. It just means I couldn't dance or wasn't terribly good looking. But
I agree. I concur. Let's submit that for the record.
It's in the record now. You know, as that wonderful reading, and I thank the reader, of the manager's amendment went on, one of the things that popped out is I suddenly went, okay, I've been around since Surf was a young man and created IPv4. I hadn't even noticed that this bill seeks to provide specific coverage of things which were precursors to IPv4. In other words, some standard of Internet protocol that predated it. Now, there is a standard. It was a military standard. I have absolutely no idea why someone would write a piece of legislation that would talk about, I can understand why you'd have successors to current Internet protocol, but I'm going to be adding an amendment just because if no one on the dais right now, including the brilliant staff, can define for me, or for Mr. Chaffetz, since it's his time, why you have to regulate things that came before current Internet protocol, I'd love to hear it, because I'm just not enough of a nerd to know why a standard that is no longer in use and cannot communicate would have to be regulated under this bill. And yet, as people quickly wrote this thing to cover all things, all way, all the time, they wrote that into the bill. On behalf of Mr. Chaffetz, can anybody, any staff help?
Would the gentleman
Reclaiming my time, yield to the gentlewoman from California.
One possibility is the suggestion made by the Internet engineers that the SOPA-induced timeouts could cause some applications to retry older insecure DNS technologies, which of course could be exploited in a downgrade attack, and it would shed the security that currently exists, not to mention the move towards DNSSEC. I'm not positive that's the case. I think it's one possibility. I thank the gentleman.
Thank you. Reclaiming my time, I'll yield back, Mr. Chairman. Thank you.
Thank you, Mr. Chaffetz. For what purpose does the gentlewoman from California?
I move to strike the last word.
The gentlewoman from California is recognized for 5 minutes.
Thank you, Mr. Chairman. I would like first to commend you, Ranking Member Conyers, Congressman Goodlatte, Watt, and Berman for undertaking this extraordinary task to craft legislation that creates a more effective legal framework for combating online privacy. Like Mr. Sensenbrenner, I have spent an inordinate amount of time making sure I understand what was being attempted here. My staff has spent countless hours engaging proponents from each of the sides on this particular operation, this legislation, and I have come to a different conclusion than Mr. Sensenbrenner. I support the manager's amendment as a step in the right direction, superior to the bill that was originally introduced. While there are lingering concerns with respect to DNS blocking that I anticipate will be addressed today, I do acknowledge that efforts were made in the manager's amendment to resolve the scope of the bill so that it doesn't broadly impact domestic sites. The original version of the bill granted virtually unfettered voluntary blocking authority and legal immunity to Internet service providers, search engines, and DNS registrars, and payment processors that stop payment and access to websites they believe are infringing. There was no requirement of credible evidence or other provisions to clarify when such actions are appropriate, and under the bill's previous definitions, it was possible for a domestic site to be voluntarily blocked. This immediately raised net neutrality and open internet concerns. The new version of the bill doesn't completely mitigate open internet concerns, but it certainly clarifies that in order to take voluntary action, the internet site must be a foreign infringing site that is dedicated to the theft of U.S. property or a site that endangers the public health. The bill further requires the action to be narrowly tailored and consistent with the entity's terms of service. While this indeed is an improvement from the original bill, I think there are legitimate concerns that this committee should take into consideration. For example, while these limitations attempt to narrow the provision, an affected website or user who is injured by actions pursuant to this section would be unable to ascertain whether the immunized party's actions were in fact narrowly tailored and taken in good faith. There is no judicial oversight, and the targeted website is not required to be notified about the allegations and the reasons why his or her site was blocked. I submit to the chair that if a site is blocked, there should be at least a notice requirement. To be very clear, I am opposed to online piracy. I firmly believe that if you write the next great hit song or produce the next award-winning film or television series, your work should be protected from infringement and piracy. Public policy should follow the money and ensure that online payment processors and advertisers are not facilitating online infringement. We should also have adequate law enforcement tools in place to go after the worst of the worst websites, and to some extent, the entire online ecosystem must be a part of the solution. And these solutions must strike a balance sufficiently protecting and enforcing intellectual property rights while also maintaining the Internet as alternative and open venue for free expression, innovation, and media diversity. The Internet has created an alternative distribution platform from which independent producers, screenwriters, songwriters, and programmers have been able to share their work with the public. With its low barriers to entry, the Internet has provided a venue for entrepreneurs of diverse backgrounds to compete against larger companies in a variety of industries. Independent filmmakers, producers, writers, bloggers, and e-business owners have all been able to launch lucrative and successful Internet careers and compete against larger corporations at relatively low startup costs. The Internet and emergence of social networking and user-generated content websites has served a vital social utility. Here in the United States and around the world, these sites allow for free and open expression, innovation, entrepreneurship, and community mobility. Websites like Facebook, Twitter, and YouTube have also created an alternative platform for members of Congress to communicate with their constituents. So, Mr. Chairman, I do hope that as this bill proceeds through committee and to the House floor, we can continue to work in a bipartisan manner, taking the input from also stakeholders who ensure we have a strong, effective, and balanced bill. But make no mistake about it, based on all of the information that's available to us, based on the chairman's very, very commendable work in the way that he has addressed many of the concerns, I certainly support this bill today. I think that we have to be very, very aggressive about piracy. I think we must be concerned about jobs. And in the final analysis, we must be concerned about protecting the intellectual properties that we have all committed to protecting in the past from this committee. I yield back the balance of my time.
Thank you, Ms. Waters. The gentleman from California, Mr. Lundgren.
Thank you very much, Mr. Chairman. First of all, I want to thank you for working on this subject and working diligently over the past several weeks to try and resolve some issues that a number of us have. Unfortunately, I find some major defects remaining with this bill. I am not a technical expert. I seek assistance from technical experts. One of my problems with this bill is we have not had the benefit of technical experts to appear and testify before us, and certainly on the same platform. So for the last 3 weeks, I have and my staff has been meeting with just about all the interested parties. And one of the challenging things about that is that it's tough enough to be able to make decisions when there is an agreement on the facts. There's dispute on the facts. There are those who suggest that the technical fix that is contained in this bill, in terms of site blocking and originally redirection, won't work. There are others that say it will work. All I know is that of those, as far as I can find to be disinterested parties that have a technical understanding of cybersecurity, they tell me that this bill causes real troubles with what we have been trying to do for the last, depending on who you talk to, 7 to 10 years, to set up an effective DNSSEC, and that because of that, this will actually have an adverse impact on our ability to protect the Internet from the kinds of cybersecurity attacks that have taken place and continue to take place. Now, again, I don't have the technical knowledge to be able to articulate that here, nor am I going to read something that would suggest that I have such technical knowledge. I would just ask, though, why is there this rush to judgment? While I understood during the time I was not here in the aftermath of 9/11 why we had to act with dispatch with respect to the Patriot Act, and I happen to be one of those who defends it and one of those who has participated in this committee in terms of some amendments we've had to that, and the continued effort on our part to ensure that there are greater protections for civil liberties, but making sure that the guts of that bill remains. I don't see a reason for us to rush to judgment here. And for the life of me, I can't understand it. And again, Mr. Chairman, with all respect, because your staff has worked with my staff over the last couple of weeks to try and resolve the concerns I have. But the problem is, I have rarely been part of a committee operation in which we have not had at least one hearing with respect to the technical experts to deal with major concerns that have arisen in both unclassified and classified settings. The conclusion I can come to is that this would be destructive of the effort that we have attempted to create in terms of cybersecurity protection. Now, maybe that's wrong. Maybe the experts that I've talked with don't fully understand this bill, yet we have asked them to look at the language that has been presented to us. But the fact of the matter is, I don't feel comfortable supporting the legislation unless those questions are answered. And so it is not my effort to try and stop a legitimate legislative attempt to protect intellectual property. I think we all would agree on that. It's one of the few things we can agree on in this place. But when technical experts tell me this is a major concern and that it undermines something that we've been dedicated to doing for the last 7 to 10 years, I have to say, why can't we slow down and at least have an opportunity to look at that? I don't know what the answer is to that. And I understand that we're going to now work through the day and maybe work through the night and have people forget about Christmas parties and not have an opportunity to hear from experts, but I frankly don't understand it. And so while I have attempted to work with the chairman, and he has made good faith efforts and his staff to work with us, and we've had conversations over the last couple of weeks, and I've met with folks, I just feel very uncomfortable about proceeding with something when there are so many question marks on it, and when the implications of us proceeding go to the essence of the protection of cybersecurity and the Internet. Again, maybe the experts I've consulted with are wrong, and I have difficulty at times even understanding the language they're speaking, but to the extent they've been able to explain it to me, there are concerns that remain at least. When we had that hearing,
The gentleman's time has expired.
well, I'll ask for an additional minute, Mr. Chairman.
Without objection, the gentleman is recognized for an additional 30
When we had
seconds.
that last hearing, there wasn't a single person who could answer the technical questions. And they all admitted that, even though a couple of them still opined. But that is very unsatisfactory to me.
I think you go to that.
And it ought to be very unsatisfactory to this committee. And it certainly ought to be very unsatisfactory to this institution. This is an extremely important issue. We better do it right. And I would just hope that we would take the time to do that. And I know that there is no problem with respect to motivation here in any way, and I'm not suggesting that at all. It's just I am frustrated with this process because so many large question marks remain in a crucial area of our intellectual enterprises in this country. And we better take the time to get it right. And I'm afraid we don't have the time to get it right before we leave Washington at the end of this month. So I would happily yield back the balance of my time.
Thank you, Mr. Lundgren. On the way to, let me recognize the gentleman from Georgia, Mr. Johnson.
Thank you, Mr. Chairman. Yeah. Brilliant minds in this room, not all of us being nerds or technical folks, but still some brilliant minds. However, certain technical issues we cannot ignore. The objections raised by Mr. Sensenbrenner, the block and redirect issues, will it actually work? Have we had the benefit of expert testimony, which allows us non-nerds and non-technical people to at least try to come to grips with the common sense and try to make a decision based on a full plate of knowledge? I think we're lacking that here. Haste makes waste. And that was the argument that came to my mind when it came down to considering the $700 billion Wall Street bailout. I voted against it because I thought that we had not taken adequate time to work out the kinks in it. And I also realized that we did not have the benefit of all suggestions coming from experts. And so that same situation holds true today. If we cannot, if there's, with all of these brilliant minds around here, if nobody can respond to the concerns of Mr. Sensenbrenner on both the block and redirect issues and also with respect to the First Amendment issues, if there's no one in this room who can respond to that in a compelling and persuasive way, then I'm kind of not feeling good about this bill. Now I'm going to listen. I understand how we got to this point. The Senate took some action. Now the House feels like it's time to get something done before we enter into an election season next year, and let's try to get something done now. I believe that that's a legitimate political concern, and I'm trying to get past my feeling about haste makes waste by realizing that perhaps now is the only time when we can solve this issue of intellectual property protection. And so I realize that a lot of people are losing a lot of money, and I think that there's something that we can do, but I'm troubled that we are put in this position to make a decision without having adequate data that satisfies us that we're doing the right thing. The only time I've had this occur was with that Wall Street bailout, and I am happy that I voted against it. And I would not want to not enjoy that same satisfaction when it comes to something as important as this bill. It's a clash of the titans: internet freedom versus intellectual property protection. We would have it advertised as a movie in advance, far in advance of when the movie were to make its debut. And we might see various portions of it as teasers. We've not had that process here. And then, boom, the movie would make its debut, and we would all enjoy the movie, but we would have had input into the final process. We've had an input into this final process, and I appreciate the good faith that the chairman has exercised in being responsive to our concerns. And I still may vote for this bill. I just haven't made my decision yet. And I do want to hear some responses to the questions raised by my fellow colleagues.
Thank you, Mr. Johnson. The gentleman from California, Mr. Ice, is recognized.
Thank you, Mr. Chairman. And I want to echo Mr. Johnson's statements. We do appreciate the work that's been done. But I also want to echo some of the earlier statements that I think are equally appropriate. First of all, that we haven't heard from the scientist. We haven't heard from Sandia Lab except through a letter. We haven't done our due diligence on something that has been brewing, quite frankly, since everyone on the first dais wasn't here when the Internet began having piracy of intellectual property, at least as to sound recordings. This is not a new problem. This is not some urgent event like the TARP bailout, like the need for the discussion on the Patriot Act that occurred earlier. This isn't some sort of an event that if you don't do it now, you won't get it at all. Mr. Chairman, Mr. Ranking Member, this is exactly like patent reform. And I think when Mr. Johnson brought it up, he hit it right on the head. Intellectual property reform. Did we do it in one Congress? No. Did we do it on a bipartisan basis? Yes. Did this body pass an awful, awful patent bill because we were told, hurry up, and Mr. Berman's looking at me because we all remember too well. We passed an awful bill where on the floor we said, this isn't what we want, but we're going to get it over to the Senate because they'll take care of it and we'll do it there. And, of course, it didn't even become law, that Congress. Getting it right before it leaves this committee has... Yes, Howard, I'd yield to the gentleman from California.
We'll make it clear. Only one of us said it was an awful bill, and it wasn't me.
Yeah, well, honesty is one of my strong traits. Perhaps it's Tourette's, but it's still one of my strong traits.
If not accuracy.
The first time we threw the bill over to the Senate, it bore no resemblance to what finally under Chairman Leahy and Chairman Smith became law. We did do patent reform, and I'm very proud that this committee is quite unified on the reforms that we did. Not everyone agreeing on every piece of it, but we passed a good bill. It took a long time, and we learned in the process the effects and unintended consequences of earlier legislation, and we made compromise. In this case, we have and the term clash of the titans is half right. We have multiple multi-billion-dollar industries who are competing for each of our ears as to what to do or not to do. That's true. But we're not going to actually resolve that here today. We're going to take time to resolve their issues. But let's talk about the little guy. Let's talk about the Internet entrepreneur who, if the Department of Justice whacks his site and then keeps it for a year, they're going to be gone. They're out of money. They're destroyed. And the Department of Justice did that relatively recently, and did it in a way in which, at least if this committee doesn't investigate, the committee next door will. We have a Department of Justice that, quite frankly, is hard to trust after last week's meeting with the Attorney General, in which we still don't have answers as to who is going to be held accountable for Fast and Furious, for thousands of weapons going. And we're certainly not going to get answers on abuses that occur within discretion of Department of Justice. So this bill, for example, has that real question of where are the safeguards for the little person that gets trampled on? Are we willing, since we're emboldening, to a great extent, plaintiffs' trial lawyers with their ability to act, are we willing to have the federal government pay out of the judgment fund if, in fact, the Department of Justice is wrong and destroys a business? Is that being discussed? You know, we've got these billionaire companies in the audience on both sides. Okay, I like both of them. I love the fact that they're major exporters and major technology producers. But are we going to have specific protection for the little guy that can't afford the lawyers and can't afford to be shut off, and as a result goes out of business and at the end of the day was innocent? So I've got to tell you, slow down is not stop. I believe this bill should become law in some form every bit as much as anybody else who is currently for it. But we're a long way from knowing how to do it. Later today or tomorrow or after Christmas, I will be offering an amendment that talks about our open system alternative that takes major portions of this and puts it in the hands of commerce and administrative law judges. And, Mr. Chairman, my time has expired. I would only say that after the first and only hearing, we had a discussion that centered on whether we should have a specialty court. Mr. Chairman, please, throughout this markup, consider the question of, since there isn't a specialty court, since it is depending heavily on Department of Justice at the Attorney General's office, maybe we should take time to answer that question as to whether or not there's a way to do this in this bill. Yield back.
Okay,
would the gentleman yield?
I would yield any time I have remaining.
The gentleman's time has expired. Without objection, the gentleman is recognized for another 30 seconds.
I yield my 30 seconds.
I'd ask you to give him a minute because I would want him to answer my question, which will take 30 seconds. First of all, there's nothing in this bill that allows the Justice Department to do anything without going to court and getting a court order to do it. But my question to you is, with your other legislation, which I think is well-intentioned and is attempting to address it, but from a, in my opinion, much more limited and not adequate both in terms of process and remedy, but do you have a hold harmless clause for an online business that's cut off from their credit card usage if they get it wrong? Do you have a hold harmless clause if you have a provision in there?
It's an excellent question,
because
I'd be glad to answer it.
But okay, well, here's my point, though. The same decisions about have to be done carefully, no matter what remedy you look at here. And the enormity of this problem requires a remedy, but that remedy has to be carefully applied.
And to answer your question,
in this bill, it requires a court order to do that.
And to answer your question briefly, and first of all, the ITC has court too, but at keepthewebopen.com, we are right now asking people to look at this bill and to add and to edit and to do it in a transparent way for that reason. But candidly, the alternative that we're doing through the ITC, which is much more narrow than this bill, is intended to affect only offshore entities. And an offshore entity goes through entire due process under our bill and is adjudicated and has a right to appeal before anything gets cut off. So in this case, where the ITC would hold, if you have a respondent who would hold a whole trial before that would happen.
Thank you, Mr. Issa.
And I guess you accept that now. Your staff is shaking their head yes.
Before I recognize the gentleman from Colorado, I just want to remind him that the individual whose place he took, Debbie Wasserman Schultz, is a strong supporter of this legislation. And I also just want to remind him that she has only taken a leave of absence. So the gentleman from Colorado is recognized.
I thank the chair, and yes, I am now sitting in this seat, Mr. Chairman, and I'm doing so in representing the people of Colorado. I bring some personal background and expertise to this issue. I have configured name servers myself. I ran an internet access provider in the 90s. I have been involved on the creative and content side ran a large electronic greeting card company. I've run a chain of movie theaters as well. So I've been involved on all sides. I have, of course, had our content ripped off, taken in India and other countries, unable to do anything about it. I can see it from the Internet access and provider side. And I think what is needed and what overwhelmingly people have brought to our attention is a balanced approach. And I'll talk generally now. We'll have plenty, this is our, of course, about the manager's amendment. We'll have plenty of opportunity to get into specifics later. When there's a new technology, it has many positives and some negatives. Every technology does. We have automobiles. They're wonderful, but people die in automobile accidents. There are ways to try to mitigate and reduce the negative impacts of technology while making sure that they can continue to contribute. Example, with the automobile, we try to have speed limit laws. Now, could we reduce the number of automobile deaths by having a 20-mile-per-hour speed limit on the highways? We could. We could do that. Don't think it would be very popular. I think it's because we in this body and the people of the country in general recognize the value in getting to and from places quicker along the highway. This bill is analogous to not ending automobiles, but to having a slower speed limit on the Internet. And yes, it is analogous to a balkanization of the Internet, which we already see to the extent that there is a different Internet available in China and Iran. And more directly, to the point of this, intellectual property itself has been used as an excuse to censor the Internet in Russia. And we would be giving our own Attorney General in this country vast powers. And when I had the opportunity to question him last week, I said, would you use those selectively? And he conceded that they would have to be used selectively because there are hundreds of millions of potential infringers under this bill. And we have experience with this when, in fact, Russia cracked down, alleging, rightfully so, no doubt, that many NGOs happen to have pirated versions of Microsoft Windows. Now, that's fairly rampant in Russia. You can go into most companies, you can go into most offices, and they will not have licenses, at least licenses commensurate with the number of computers that it is installed on. And the problem is likely in the millions or tens of millions of unlicensed copies. However, when given the ability to selectively enforce, where did they go? Well, they happened to go to NGOs that supported free speech, open dialogue, perhaps opposed some of the government's policies, and they raided and seized computers from dozens of outspoken advocacy groups. It is very dangerous to give the government and the Attorney General in this case a power which can in fact only be used selectively, because the scope of the issue and the scope of the powers is so broad that it would take an unfathomable enforcement authority to enforce every case. Look, when VCRs were created potential piracy of movies, copying of movies illicitly. The answer is not to ban VCRs. Congress at that point took steps to try to mitigate that as well. And likewise, Congress should act and act boldly and thoughtfully with regard to reducing online piracy. I'm impressed that the chairman began by reading a few of the groups that support this effort. Mr. Chair, I'd like to submit to the record a group of some of the hundreds of opponents of this bill without objection.
Without objection, be made a part of the record.
Including major American companies like American Express, AOL, eBay, PayPal, Twitter, Yahoo, many of the founders of the Internet itself, many of those who are responsible for the technical architecture of the Internet. I have not seen a single member of that group support this bill. Civil liberty and public interest groups like ACLU, the law libraries, the librarians, EDUCAUSE, representing institutions of higher education, have all opposed this bill and taken that position as well. Many industry associations, including the Computer and Communications Industry Association, Tech America, the Net Coalition, thousands and thousands of websites. And yes, constituents and consumers have taken it upon themselves to contact our offices because they care deeply about this bill. In fact, several organizations, including Tech Freedom, the Competitive Enterprise Institute, and Americans for Job Security and Americans for Limited Government, not only join the concerns about this bill, but have actually sent a letter suggesting that we delay the markup so we have the opportunity to get this bill right.
The gentleman's time has expired.
Sure. We look forward to exploring many of the particulars of this bill over the course of the discussion of the amendments, and I yield back the balance of my time.
Thank you, Mr. Polis. The gentleman from Iowa has been patient, but he is recognized for the purpose of offering an amendment to the amendment.
Thank you, Mr. Chairman. I have an amendment at the desk.
Clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 3261.
Mr. Chairman, I ask unanimous consent the amendment be considered
Without objection, the
approved as
amendment will
read.
be considered as read, and the gentleman is recognized to explain his amendment.
Thank you, Mr. Chairman. I wasn't sure there wouldn't be an objection to that. We read through this bill and looked for something that we could find some universal agreement upon, and did settle upon the exemption for domestic Internet sites as being something that I think we have broad agreement from Democrats and Republicans and proponents and opponents of the bill. In fact, the intent of the manager's amendment, if I am interpreting the intent correctly, is that we do exempt domestic Internet sites from the jurisdiction of this bill because there's an existing jurisdiction, some of it primarily under 18 U.S.C. 2323. And so when I looked at the language of that defines domestic Internet sites, it says that it be a domestic domain name or a domestic IP address. And those are good components of the definition, but it did not include the domestic U.S. Internet sites that also operate in foreign countries and simply will happen to change the domain name to indicate the country, such as a .uk for United Kingdom or .de for Germany or a .nl for the Netherlands, for example. And so I've offered an amendment that adds to that definition language, and it says an Internet site operated by an entity that is located within a judicial district of the United States, which means that the intent is to protect these Internet companies that operate from the United States that are already subject to the jurisdiction of our U.S. courts. And that's the intent of this language, and I understand we'll have a little discussion regarding it, so I would be happy to yield.
Gentleman yield? Would the gentleman yield to me first?
I would yield to the chairman.
I thank Mr. King for yielding. I just want to say to the gentleman, I think he has a legitimate point. I want to make sure that there are no unanticipated consequences of the language, and so I would expect to be able to reach an agreement with him between now and the House floor on acceptable language covering the point that he just described.
Gentleman yield.
I'd be happy to reclaim and yield to the gentleman from Virginia.
Well, thank you. The gentleman and I have spoken. I think the gentleman has a good idea, and I am sympathetic to the issue that he raises. In fact, it addresses part of the concern raised by the gentleman from California, Mr. Issa, just a little while ago. The manager's amendment excludes domestic sites like Facebook, Twitter, and eBay. The question is simply whether foreign registered websites owned or operated by U.S. companies such as Amazon.co.uk might still be covered. I don't think they'd be covered since the bill also excludes sites that are not operated as U.S. directed sites. The reason companies set up a separate UK site is to attract and serve a non-U.S. market. They are not a U.S. directed site that would be subject to the bill. Even if that weren't the case, such sites would not meet the new tightened criteria for a site dedicated to the theft of U.S. property unless that site was itself a site primarily operated for the purpose of infringement. Having said that, I appreciate the amendment and agree with the principle behind it, and would also commit to working with him to ensure that it does not cover domestic entities. What I want to make sure, however, is that there's not some kind of a giant loophole created where a foreign site adopts the minimal contacts with the United States to establish that legal jurisdiction, but have no presence in the United States, no assets in the United States. We've exempted all U.S. companies on the premise that they can be reached under existing copyright law. I agree with an extension of a U.S. company that has a foreign domain name, but I want to make sure that that is the limitation of what we're trying to accomplish and not create a loophole for foreign sites. So I'd ask the gentleman, if he would, to withdraw the amendment and work with us to accomplish that goal.
In reclaiming my time, and I appreciate the points made by both Chairman Smith and Subcommittee Chairman Goodlatte on this. We are working to get the same thing accomplished, and neither do I want to see a loophole that might be inadvertently slipped into this language, and especially the gentleman, Mr. Goodlatte, has made a point that causes me to be concerned that we don't have this language refined tightly enough, and I'm happy to go forward and work on this with members of this committee, and I'd ask unanimous consent then to withdraw this amendment.
With that objection.
With the gentleman yield.
Reserving the right to
Thank you,
object.
Mr. King.
Reserving the right to object.
Who reserves the right to object? The gentlewoman from Texas, Ms. Jackson Lee.
Thank you very much, Mr. Chairman. Let me raise the question of Mr. King's amendment and possibly pose a question to the gentleman. But as I do that, let me make several points on the underlying bill. I think all of us are opposed to online piracy. It is an unacceptable practice that must be addressed. And I believe that any website that systematically engages in violating the intellectual property rights of others should be shut down. My vote today will reflect on how we have answered the question fairly. I am certainly opposed to copyright infringement, and for those of you who remember the late Chairman Henry Hyde, we began to work on those issues even then. The question is, of course, how this legislation will impact the enhancement of jobs or the denial of jobs. And certainly I'm concerned about all of those who are tied to the industries of intellectual genius, such as the media and movie industry, and clearly we do not want to enhance the loss of jobs. But at the same time, I've heard, or you may have heard me use this philosopher before, can we all get along? Stated by Rodney King. And right now, it does not look like we are all getting along. Under the DMCA, an internet company that serves as a conduit for third-party communications receives a safe harbor from liability if it creates a process to respond to a copyright owner's notice about infringing content on the internet company's platform. That is to protect. But there are sufficient loopholes here that would allow innocent sites to be shut down, thereby a loss of jobs. Have we answered the question dealing with national security? And as well, are we recognizing the value of the First Amendment? So there are several amendments that will be offered, some that I have offered that track, I believe, the underlying premise of Mr. King's amendment in a different approach. But I do believe that in this time of promoting genius, attempting to encourage the survival of small businesses who are job creators, and the importance of our national security, and of course, the important component of the Bill of Rights that allows us freedom of access, freedom of association, freedom of religion, freedom of assembly. The question is, how much does the underlying bill interfere with those basic premises that Americans hold dear? And I cannot fathom why we are moving so quickly on a bill that may in fact save billions of dollars or in fact cause us to lose billions of dollars. And why would not find a way to protect the intellectual genius but not stifle the creativity of many? And so I'm concerned that there may be an inadvertent restriction by this underlying bill. There's a possibility that law enforcement officials could target all sites that contain infringing content, regardless of how insignificant that content may be. I strongly support the protections of the legitimate copyright interests of online content producers. However, it appears that the burden of this legislation in its current form could in fact impact innocent producers. For all of those who are interested in this, find a way to encourage members to not take my way or the highway, and find a way that we could, as we did on the patent bill, over a period of almost a decade. Obviously, it was not that long. 6 years comes to mind. Maybe I'm thinking of starts and stops that we had. But it took a period of thoughtfulness. I don't want young people who are excited about the internet, who have on their mind, I'm in a startup, I'm creating a part of America's economy. I'm excited about the potential to then be denied equally to those who have created great entertainment that we cherish to be denied as well.
Will the gentlewoman yield?
I'd be happy to yield to the gentleman.
I just want to quickly, Mr. Chairman, make a point that with all due respect, that if we can't get the definition of domestic internet site right, this bill probably isn't ready for prime time. So we had an original one, we had a manager's amendment, now we have an amendment that I offer by Mr. King. I understand he's withdrawing. I think the spirit of doing that is right. But
gentlemen,
if you get
I'm going to have an additional 30 seconds for the gentleman to conclude. And
without objection, the gentlewoman is recognized for an additional 30 seconds.
Gentleman concluded, but let me reclaim my time and just thank you, Mr. Chairman, and just indicate, let's not quash the genius of all aspects of those.
Does the gentlewoman from Texas continue to insist on her objection to the unanimous consent request by the gentleman from Iowa?
I'm getting ready to put that sentence in, Mr. Chairman. Let us all find a way to have a common ground, and at this point, I withdraw my objection at this time.
Mr. Chairman?
The gentleman from Iowa withdraws his amendment.
Mr. Chairman, I had reserved the right to object as well.
I am told that a unanimous consent is not required to withdraw an amendment, and therefore there cannot be an objection to that unanimous consent request. Are there other amendments to the amendment?
Mr. Chair, I'd like to offer the King Amendment as my own amendment so that I can have time on it, and if anybody else would like to strike the last word, as the Polis Amendment.
It's been withdrawn.
Okay.
If it wants to reoffer, it'll go at the back of the line.
Same language.
Okay. The King.
Mr. Chairman, that requires unanimous consent, and I object.
I don't believe it requires unanimous consent.
I don't think it requires unanimous consent. Let me say to the gentleman from Colorado that if he's going to offer a new amendment, that will go to the back of the line per our agreement. And so the next amendment up, if he still wants to offer it, would go to Mr. Johnson of Georgia.
Thank you.
Mr. Chairman.
The gentleman from Georgia.
I'm withdrawing my amendment number 2 on our sheet here, but it's actually 095.
Okay. Thank you, Mr. Johnson. The gentleman from Colorado, Mr. Polis, is recognized.
Thank you, Mr. Chair. This is, I assume, for Amendment 81, not the reconfigured amendment. Is that correct?
Yes. The gentleman is correct.
Okay, one moment. So this amendment clarifies the definition of non-authoritative domain servers to ensure the bill is aimed at...
let me back up for a minute. Does the gentleman have an amendment at the desk?
I have an amendment at the desk.
The clerk will read the amendment.
Amendment to the Smith Amendment offered by Mr. Polis of Colorado, page 8.
Without objection, the amendment is considered as read, and the gentleman from Colorado is recognized to explain his amendment.
Thank you, Mr. Chairman. My amendment is very simple, hopefully something that we can agree to. I believe it addresses something that was mistakenly admitted. Is this microphone on? Yes. It clarifies the definition of non-authoritative domain name servers to ensure the bill is aimed at for-profit and commercial activities and not the internal DNS servers of universities, research institutions, and local governments, which would cause significant additional burden for these entities. Under the current bill, a service provider must take steps to ensure that non-authoritative domain name servers don't enable access to road sites. However, the definition of service provider is so broad that it covers every non-authoritative domain name server. The bill doesn't currently make any distinctions among different non-authoritative domain name servers, even those that are used strictly for local traffic within a particular institution. The university could be, under this definition, a service provider and therefore be required by court under Section 102 to block access to a foreign infringing site, regardless of whether any students at the university have ever even used that site, and would have to incur significant technical compliance costs as well as potential legal liability with regard to those efforts. In fact, if the Attorney General thinks the university isn't meeting its obligations as a service provider, it could be subject to an enforcement order in a 102c3. So while the bill does make an exception for business on page 9, line 5b in the definition of service provider, it would currently impose a burden on other types of organizations like universities. So my amendment would simply clarify the definition to help make sure that the costs at universities of technical compliance and legal fees do not go up. We are not talking about the internal DNS servers of universities, research institutions, and local governments. It's critical to make sure that we don't impose excessive red tape and compliance costs on already cash-strapped nonprofits and institutions devoted to research and education, including many that are in my district in my state, like the University of Colorado, Colorado State University, NREL, NOAA, and NCAR, and UCAR, federal labs and collaboratory labs between the universities. So, again, I think this is consistent with the intent of the bill and would provide some of the same protections for universities as nonprofits that are provided definitionally on page 9, line 5B for for-profit service providers. And I will yield back the balance of my time.
Thank you, Mr. Polis. The gentleman from Virginia, Mr. Goodlatte, is recognized.
Thank you, Mr. Chairman. The gentleman's amendment carves out nonprofits and universities from the DNS filtering provisions of the bill. Though I recognize the need to be sensitive to the concerns of universities and government entities, I oppose the amendment. The terms of the amendment are not precisely defined and could create a loophole that could undermine the provisions of the bill. The exclusion for not-for-profit research institution could be applied too broadly. Potential exists for a not-for-profit ISP to be set up wholly devoted to infringing activity, and in such an instance, law enforcement would be prevented from taking appropriate action. We do recognize the concerns raised by this amendment and look forward to addressing these, but I must oppose the amendment. And I yield back.
Thank you, Mr. Goodlatte. The question is on...
Mr. Chairman, I'd move to strike the last word.
The gentleman from California, Ms. Lofgren, is recognized.
As I look at Mr. Paulus's amendment, I think it's incorrect to say that it's imprecise. In fact, I think it's quite precise on what it would exempt. And I guess I would yield to Mr. Paulus for a question. As currently drafted, the manager's amendment is exceedingly broad. And here's the question. The House of Representatives runs an entity. Wouldn't we be covered? Wouldn't the Attorney General, absent your amendment, be permitted to come in and make enforcement efforts against the House of Representatives?
I thank the gentlelady for the time, and yes, that is correct. We are a government entity, are not exempt under this, and currently we would be effectively giving the Attorney General's office the ability to give Congress an enforcement order under 102(c)(3). And again, giving any Attorney General of any party effectively a selective ability to do this sort of thing is bad precedence. And I understand there are those in this committee that are not fans of the current Attorney General and those that are. I think it's fair institutionally to say that regardless of who the Attorney General is, that's not the type of power that we would want to give to an Attorney General, nor should we over universities, the bastion of academic freedom and thought. In fact, absent this amendment, this manager's amendment could ironically be counterproductive in the sense that it could stifle research done at universities into how to stop piracy, which is the exact opposite of its intention. So I hope that we can, again, ensure that government entities, not-for-profits, research institutions, and institutions of higher learning are, in fact, clarified that they are not included as non-authoritative domain name servers subject to court orders to block access. Also very onerous from a cost perspective for small nonprofits.
Would the gentlelady yield?
I yield back.
No, let me finish, and then if I have time left over, I will. But I think this goes to the point that has been made by several members on both sides of the aisle, which is this measure, I don't think, is ready for prime time. Mr. Sensenbrenner and I have often discussed the speech and debate clause issues that often come before us in odd ways. I'm part of the committee that gives advice on speech or debate questions. A sleeper issue in this bill that I think Mr. Paulus's amendment has now brought forth is the ability to allow, under the manager's amendment, the Attorney General to enforce orders against the House of Representatives when the speech or debate clause would seem to indicate that he lacks that authority. I think Mr. Paulus's amendment, which covers far beyond the House of Representatives is the appropriate amendment. But I would note, if this is not adopted, the speech or debate issue that has been raised by it certainly does need to be addressed. And I think it would be a serious mistake to simply dismiss this in a headlong rush to try and get a bill that is not ready to be adopted done somehow before we adjourn for the Christmas recess. And yes, Mr. Berman, I think, have time. I would be happy to yield.
Well, I mean, the gentleman from Colorado raises an interesting issue of selective discretion. This is not a new concept for attorney generals or law enforcement figures. Every case creates opportunity for selective judgments on who to pursue. But until I hear the answer to the hypothetical that Mr. Goodlatte raised, I would argue that in order to protect the House of Representatives or the Justice Department, we are going to include some operation that wants to develop a website primarily dedicated to infringing material and organizes as a non-for-profit research institution.
Reclaiming my
oppose
time. The problem is that there are really no procedural protections when you look at the safe harbors in this measure, and so you have the opportunity for suppression of thought. And we don't want to say that the current Attorney General will do that, but our job is not to rely on whoever's holding that position. Our job is to set up a structure that cannot be abused. And I support the gentleman's amendment. If it is not adopted, I will, at some later date, address the issue of the Congress and the speech or debate issue that has been addressed here. We've gone all the way to the Supreme Court to make clear that the executive is not permitted to interfere with our speech.
Well,
and I yield back.
Gentleman's time. Thank you. The gentleman from Florida, Mr. Deutsch, is recognized.
And I thank the chairman. This is an interesting amendment. It raises concerns about academic freedoms being threatened, and now the speech and debate clause of the Constitution is brought into play, and thought may be stifled on the internet. That's not, unfortunately, that's not what would happen under this bill. This is not. There's nothing in this legislation, in any interpretation of this legislation, that would permit the stifling of academic thought. The fact is, there's no reason that a nonprofit that doesn't take money from advertisers, or a university that doesn't take money from advertisers or for its services, shouldn't be included in the bill. If you meet the high standard in this bill of stealing, then it doesn't matter whether you pay taxes on those proceeds or not. There's no liability under this bill for these entities. There's just a requirement that they behave like other domain resolution services and prevent access to these offshore rogue sites. That's what's happening here, and I oppose the amendment.
Thank you, Mr. Deutsch. Other members wish to be heard on the amendment. The gentlewoman from North Carolina, Mr. Watt.
I think we've kind of gone beyond the scope here. I just I want to re-emphasize what Mr. Deutsch has said, but none of this action can take place without just by the Attorney General's waving a magic wand. You got to go to court and get an order that allows it. He goes to court. If we have speech and debate issues, somebody is going to show up and raise those issues in the court. If there are other kinds of issues to be raised, somebody is going to show up and raise those issues in the court. The judge is not stupid. And I appreciate what the gentleman is saying. I'm against selective prosecution, selective enforcement of stuff, but that's why some stops have been put in the manager's amendment. And for us to just kind of go overboard and say, you know, this is going to allow abuse of universities and people on university campuses, and it's going to allow the Attorney General to say that we are not, you know, that our speech and debate provisions are not protected. I mean, that is just so far outside of what we ought to be trying to represent to people out here. It's just not the case.
Will the gentleman yield?
I'm happy to yield to the gentleman.
I thank the gentleman. And again, what we're talking about here on page 15, a service provider is required to take such measures as are reasonable, et cetera, to prevent access by its subscribers located within the United States to the foreign infringing sites. And again, this is effectively an unfunded mandate at its best to the universities.
After a judge says that, not based on the Attorney General calling up the service provider and saying, take this down. Give me a break.
Will the gentleman yield for one moment?
Yes, sir.
Again, the universities and nonprofit research institutions are not making any commercial gains from these transactions. They should be bastions of academic freedom.
Whether they are making commercial gains or not, if they are stealing my property and allowing their students on their property, if we're doing it in the house computers, we ought not be allowing it. Wait a minute now. Hey, let's get real here. I couldn't go out and steal somebody's stuff and bring it into my office here in the House and then claim I have some speech and debate protection against that. The police could come into my office and take it. I can't put something up on a computer that I've stolen and then say to the Attorney General, you can't go to court and even file a cause of action against me. Come on, give me a break here.
Well, the gentleman yield for one additional moment. All the examples that you cited are already against the law. It is already against the law to download illegal material, and that is the right law.
I'm going to quote my good friend Barney Frank. Redundancy, you know, in the law, you know, if we're just doing this, something that's already in the law, that doesn't bother me. I mean, your objection even bothers me more if it's already against the law, because we're just enforcing a law that already exists, right? So I mean, that I am not persuaded by that. I think we've gone overboard here to try to make a point. Now, I appreciate the point you're trying to make, but to try to make it sound like there's some legitimacy to it, and that the Attorney General can just walk into a university and take down stuff just by making a phone call is just inaccurate under this bill.
Will the gentleman yield?
Who's read the bill?
Will the gentleman yield?
Where's Louis?
Will the gentleman yield?
Yeah, I'll yield to the gentleman. Go ahead.
What, if this bill applies only to foreign-based rogue websites, then how would it apply to?
Well, you just ask Mr. Paulus that.
The gentleman yield.
Any university that's got a foreign-based website.
The gentleman from
all the more reason.
The gentleman from Georgia yield.
The gentleman from North Carolina's time has expired.
Mr. Chairman.
Mr. Chairman, may I?
The gentleman from California, Mr. Ice, is recognized.
Thank you. And I'll be yielding to continue this dialogue. But, Mr. Chairman, I think that a point was just made and made rather illustrative. This is not a foreign stopping bill. The fact is that that any case brought against somebody in Timbuktu or other countries often mentioned will be a default judgment, whether it's in the ITC or, in fact, it's using our court system. That's a given.
Ex parte, you mean?
Well, not ex parte. We will attempt to serve in that foreign country, and they will, in fact, not answer. It is unlikely they are going to invest in lawyers and go through the whole process. So it's not ex parte. The fact is that no matter where the case is brought that initially is against a foreign entity, the whole idea is the foreign entity doesn't have assets here and is not going to respond. If they do respond, they almost stop being a foreign entity, and that, in the case of some companies, will occur. But for the ones that we're always mentioning that we have to stop and we have to have this law, these are going to be default judgments. And then once the default judgment is done, we're doing something we don't normally do in civil case, and we're certainly doing something that I don't think is a good idea, and it is not in the current law in this way, where we basically say to the Department of Justice, you go get a gazillion indictments or a gazillion estoppels of some sort, and you do it like you get a bologna sandwich indictment, because ultimately these are going to be glorified John Does, and they're going to be slammed through by the thousands, hundreds of thousands, and they are going to include universities, and they are going to include everywhere. This is part of the problem. It will not be court supervision. I would yield to the gentlelady.
I think the point you're making is a good one, but I wanted to address the constitutional issue, because I think it's an important one, and it's not always well understood by the public at large. I'm sure the members understand. Article 1, Section 6 says that the members, for speech or debate in either house, the members shall not be questioned in any other place. And by extension, that includes activities that we do not only on the House floor, but what we do in terms of speech, our websites, and the like. And it is true that I could go to the floor of the House and I could infringe content. I could read something that is copyright protected, and I would not be held to answer in any other place. And it is simply not the case that in the process of legislating that we are held to an infringing standard. That would be equally true for our website. Now, the gentleman from North Carolina is correct. There is a judicial process here. I'm not disagreeing. But we have fought all the way to the Supreme Court on multiple occasions to keep the Attorney General from imposing his, and in a prior instance, her, actions on our legislative activity. This, in my belief, is not a frivolous issue at all. It is an issue that's serious, and that if it is not addressed in this amendment, I will offer to address it at a later time. I just wanted to clarify that, and I thank the gentleman for yielding.
Would the gentleman yield?
The time.
Would the gentleman yield? The gentleman from California has the time.
You're exactly right. This is an example where this bill is not ready for prime time, where these issues need to be asked and answered. As we speak right now at keepthewebopen.com, people are hearing what we're saying, and they're going there, and they're trying to figure out how they could see this bill change to be more narrow and more appropriate. But ultimately, I'll go back to the earlier point I was on. This bill is a domestic bill. It is a domestic bill, lock, stock, and barrel, and it says essentially, forget about the existing criminalization. We've got this whole new band of criminalization that we're going to have, and we're going to use the Department of Justice to do it. Ladies and gentlemen, when I offered an alternative bill to take care of, if you will, foreign entities and then follow the money using the ITC, one of the things that came up that the press kept saying, but unknown people are saying this would not work because it would be expensive. I want to make it clear, under the current language of the bill, you have an incredibly burdensome, expensive system. You have a system where you're expecting the Department of Justice to prefer doing this fairly over going after terrorism and all kinds of other crimes. What you're going to get is anecdotal enforcement, selective enforcement, maybe even politically motivated enforcement or ideologically enforcement, and you're going to get all of that.
The gentleman's time has expired.
You're going to get all of that in the least efficient way.
Okay. The gentlewoman from Texas, Ms. Jackson Lee, is recognized.
Thank you very much. Restate my comment about how do we find a common path. But I want to pose the question to Mr. Polis, even separate from speech and debate, and see if I'm getting at part of the heart of his amendment, which I think is thoughtful. When you think of universities, nonprofits, and governmental entities, they are huge. Many have access, and out of that access comes that large if you will, element in the room of someone using it inappropriately. The question is that universities and nonprofits and others have a ultimately good purpose, and there is a potential for the negative impact overall. I'll pose this question to you, for the actions of the minute. I think I'm correct when I associate Facebook's origins with a university. Whether that was appropriate at the time, we'll have to ask Harvard. But seeing that as a potential, I truly believe that the murkiness that we are seeing in this legislation would in fact put everybody in the soup. So, Mr. Poles, my question is part of your focus in this amendment to bring a clarity that in fact protects the innocent institution for what can be a massive shutdown? And someone argues that there's not advertisement. In this new climate of raising money, there's all kinds of advertisement by governmental entities, nonprofits are advertising, and I would imagine universities. Let me yield to the gentleman for my question.
Yes. The best possible implementation of this would result in an unfunded mandate for universities to comply with these orders. They would need to add technical personnel to do so. At its worst, it could very well stifle academic freedom and discourse. Again, as Mr. Ice has said, this is an America-facing bill. We're talking about actions that American universities, American businesses are forced to take in response to dislabeling. It's not my time. I'm just answering the lady's question, and I want to make sure I answered your question. Did I answer the lady's question?
I'd be happy to yield in just a moment. I think the concern that I have again is whether we could narrow this to what we are against, and that is online piracy and the protection of intellectual property. I see your amendment as protecting entities that are going to be exposed because they have so many users for specific reasons, whether it's the First Amendment, whether it's research, whether it's students. They're all using it.
And that's correct. And if there is illegal activity, that needs to be prosecuted.
Absolutely.
That needs to be prosecuted. There is no tolerance for piracy. There's no tolerance for illegal activity. But you don't want to engender additional costs, legal liability, and potential for selective Attorney General action for an entire nonprofit or university.
I yield to the gentleman from North Carolina and then the gentleman from Florida.
This bill is about foreign sites. I don't know of any university that's operating foreign sites. I think this is a red herring, and one of many that I suppose will be raised today. But I just want to be clear, when you're looking for clarity, look at the bill and look at the definitions of what the bill does. This is not, there's no universities that's operating foreign sites. There's just not, they don't exist.
Will the gentlelady yield?
Let me reclaim my time, and I appreciate the gentleman. He's absolutely right. What happens in murkiness and leakage is the possibility for the impact on these entities. Let me yield to the gentleman from Florida.
I thank the gentlelady for yielding. I would very much like the amendment sponsor to tell us in some detail how it is that legislative debate and academic freedom will be stifled by this bill.
I'll be happy to yield to the gentleman, Mr. Polis, for his response to the gentleman from Florida.
Thank you again. And again, in response to the gentleman, Mr. Watt and Mr. Deutsch, we are not talking about what we are doing for foreign sites. We were talking about the affirmative burden on American universities and nonprofits to block foreign sites that are covered under this bill. The affirmative burden, again, that requires additional technical compliance at the universities, that under a separate section of the bill, we already block operators of non-authoritative domain servers that offer their services to businesses.
Will the gentlelady yield?
I'll be happy to. If I might reclaim my time, and then I'll yield, give additional 30 seconds. We're talking about
the time has expired. Without objections, you'll be recognized for an additional 30 seconds.
Mr. Chairman, thank you for your kindness. I think, and I will yield to the gentleman from Florida, I think the overall message of Mr. Polis's amendment and my premise of how we come to a common point is the overreach and the overbreadth and the potential of the impact of a domestic site such as those involving vast internet servers like you find in government and universities. And I might just conclude by saying, who knows who's reaching out from a university site, which draws then the premise of the oversight of this particular bill. And there they go. Mr. Gentleman from Florida.
Gentleman has 15 seconds.
I
thank the gentleman.
I thank the gentleman, and I thank the chairman. I understand Mr. Pulse's objections to this bill, and I understand that he doesn't support it. But the charge that's been made is that this legislation would threaten academic freedom and the legislative debate that takes place in this body. That's a dramatic charge, and simply saying that this isn't ready for prime time and making the argument that we're going to stifle debate is a significant claim, and I've not heard an answer that tells me in any way how that claim could be justified.
Someone's time has expired. Question is on the amendment to the amendment. All in favor say aye.
Mr. Chairman, I had asked for time also.
We will hold the vote, and the gentleman from Georgia is recognized.
Thank you. I didn't get a quite a good answer for my question. Mr. Deutsch tried, or Mr. Deutsch did narrow it a bit, but from what I understand, Mr. Polis, this amendment would enable universities and would also enable the congressional servers, of course subject to speech and debate clause, to offer counterfeit material on their websites. Is that what this does, is carves out an exemption for universities to be able to offer foreign-based stolen content?
No, my amendment does not offer immunity to anybody.
Isn't that the effect of it?
No, it would simply clarify the definition in a way that I thought was consistent with the intent of the bill, and Mr. Goodlatte insinuated that it was consistent with the intent of the bill and offered to work on it. Again, I think it simply clarifies the definition of non-authoritative domain name servers to ensure that the bill is aimed at for-profit activity, not the internal DNS servers of universities and research institutions. It does not let anybody off the hook for violating copyright whatsoever.
What would be the impact of your amendment on a, let's say, private, for-profit university that finds itself accused of offering pirated content on their web servers that came from overseas?
If they were offering the content that was pirated on their web servers, they would be in violation of the law, and I believe the body of law is sufficient to force them to take it down, and they would act expeditiously or face significant civil and criminal penalties under existing law.
So how does this legislation, which deals with foreign rogue websites, impact university freedom? How does it actually do that?
Again, the primary argument I made is unfunded mandate. At its worst, it impinges upon freedom. Again, when we're talking about this balkanization of the Internet, these different Internets that exist, effectively this would empower the Attorney General to say, university, you need to create a different Internet that no longer has this or that as part of the Internet that you have.
Why should the Internet be, or why should a university be treated differently than, and by the way, you got profit and you got nonprofit and for-profit, private and public universities. Why should any subclass be treated differently?
They should not be included in the definition of service provider because we actually already omit many businesses. In fact, we omit under the definition of service provider on page 9 businesses that offer domain name resolution services solely to businesses for domain, subdomain, domain name systems, or Internet protocol address management. So that would be a company like GoDaddy would already be exempted. So, I mean, if companies like GoDaddy are exempted, why are non-commercial domain name servers. And again, many universities, our DNS have their own internal DNS. Why would we not exempt the non-commercial ones if we're exempting the commercial ones?
Thank you. I'll yield back.
Thank you, Mr. Johnson. The gentleman from Tennessee, Mr. Cohen, is recognized.
Thank you. Let me ask Mr. Watt a question. Do you know about this exception for businesses, and can you explain to me why that's in the bill? Or Mr. Smith, whoever can answer the question.
If you'll me to the section that he's talking about.
Page 9.
Apparently, page 9, lines 8 through 10. There's a 13. And if Mr. Smith anybody can answer it. It's an open question.
If the gentleman will yield, it's my understanding what we were trying to do was to get to the major ISPs and make sure that other individuals would not be considered an ISP and therefore give them some degree of protection.
And further, I'm not sure this would be the section under which universities' servers would be covered anyway.
If I understand the amendment,
service providers,
and I may be wrong, and maybe it does or doesn't relate to businesses, would this basically say if there is copyright infringement and you're trying to enforce your rules, that universities would then be immune from that, and that college students or people on the college server could watch whatever they wanted? Would that be accurate?
I think what it says, what I believe Mr. Paulus's amendment says, is they wouldn't have to make any efforts to take it down. They wouldn't have to go out of their way. But there's a provision in the bill that says nobody's required to do anything that they can't technologically do anyway. So, I mean,
well, let me ask Jared to explain.
Yeah, I don't think that this amendment does what some of the people here have argued against. It simply changes the definition of service provider under this bill. We already make many exemptions to who service providers are, and the chair pointed out we want to capture the major ISPs as service providers. That's consistent at least with the goals of the bill. I agree with the current exemption. I think it's good that we're exempting domain name servers that offer domain name resolution services to businesses. Again, an example would be GoDaddy. An additional and similar one, consistent with the intent of this bill, would be universities that are not in any way, shape, or form commercial service providers and should have the similar requirements under this bill as anybody else. This does not provide any immunity. My amendment provides no immunity for any violations of the law. And that's not what it does. It simply defines service provider in a way that I think is consistent with the intent of this proposal.
Yield the balance of my time.
Gentleman yields back his time. The question is on the amendment. To the amendment, all in favor say aye. Opposed, no. No. The opinion of the chair, the noes have it. The amendment is not.
Mr. Chair, on that I request a vote.
Recorded vote has been requested. The clerk will call the roll.
Mr. Smith? Mr. Smith votes no. Mr. Sensenbrenner? Mr. Coble? Mr. Gallagly? Mr. Goodlatte? Mr. Lundgren? Mr. Shabbat? Mr. Issa? Mr. Issa votes aye. Mr. Pence? Mr. Forbes? Mr. King? Mr. Franks? Mr. Gomert? Mr. Jordan? Mr. Jordan votes aye. Mr. Poe? Mr. Chiefitz? Mr. Chiefitz votes aye. Mr. Griffin? Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Gowdy votes no. Mr. Ross? Ms. Adams? Ms. Adams votes no. Mr. Quayle? Mr. Quayle votes no. Mr. Amade? Mr. Amade votes no. Mr. Conyers? Mr. Conyers votes no. Mr. Berman? Mr. Berman votes no. Mr. Nadler? No. Mr. Nadler votes no. Mr. Scott? Mr. Scott votes no. Mr. Watt? Mr. Watt votes no. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson Lee? Ms. Jackson Lee votes aye. Ms. Waters? Ms. Waters votes no. Mr. Cohen? Mr. Johnson? Mr. Johnson votes no. Mr. Pierluisi? Mr. Quigley? Mr. Quigley votes aye. Ms. Chu? Ms. Chu votes no. Mr. Deutsch? Mr. Deutsch votes no. Ms. Sanchez? Ms. Sanchez votes no. Mr. Polis? Mr. Polis votes aye.
And the gentleman from Wisconsin.
Mr. Sensenbrenner votes aye.
The gentleman from Arkansas.
Mr. Griffin votes no.
The gentleman from Virginia.
Mr. Goodlatte votes no.
Other gentleman from Virginia.
Mr. Forbes votes no.
Gentleman from California.
Mr. Gallagly votes no.
Other gentleman from California.
Mr. Lundgren votes aye.
Gentleman from Arizona.
Mr. Franks votes no.
Gentleman from Iowa.
Mr. King votes
Gentleman from Ohio.
no. Mr. Shabbat votes no.
Are there other members who wish to be recorded on this amendment? The clerk will report.
Mr. Chairman, 9 members voted aye, 23 members voted nay.
Majority having voted against the amendment is not agreed to. Are there other amendments? The gentleman from Colorado is recognized.
I have an amendment at the desk.
The clerk will report the amendment.
Amendment to the Smith Amendment offered by Mr. Polis of Colorado, page 7, beginning on line 15, strike or if there is no domain name.
Without objection, the amendment will be considered as read. The gentleman is recognized to explain his amendment.
Thank you, Mr. Chair. Domains are popularized and used via their domain name. That is a .com, a .net, a .biz. It is the word that everybody is associated with the product or brand. However, there is also an IP address that is associated with each domain name. The IP address is a string of numbers that generally does not have consumer awareness. It might look like 128.24.44.5599 or something like that. In fact, a single IP address can be associated with more than one server or device. For example, multiple computers that access the internet through a shared router might have or appear as they have a single IP address. Likewise, within a single computer, it can have several IP addresses and host a number of them. Many networks use dynamic IP allocation to assign IP addresses to servers and devices on the network. So today's valid IP address might be tomorrow's invalid IP address. And this isn't just a theoretical problem. There's been many examples of rights holders bringing copyright infringement actions against innocent individuals based on subpoenaed IP addresses that are no longer or were only dynamically associated with individual for a brief point in time. I believe that what we're dealing with in this bill, hold on. In this bill, we should be dealing about the domain names, and it is simply pulling in a whole another area if you're pulling in every device that has access to the internet with an IP address. The manager's amendment is currently ambiguous as to whether a network device, such as an iPad, for instance, or someone's home personal computer, or a refrigerator, or a toaster, can constitute an internet site because it is, quote, collection of digital assets accessible through the internet, end quote. It has no domain name, but it does have an IP address. So again, if your toaster has an IP address and you are remotely controlling it, I would argue that it is not, in fact, a website. If it is toaster.com and people can go there and access it, then it looks and feels a lot more like a website. My amendment would simply make that distinction. I'd like to submit to the record a recent New York Times article that describes a study from University of Washington, Mr. Chair. Without objection?
Without objection.
Thank you. And this study found that because enforcement agencies are looking too often only at IP addresses, they are often improperly accusing people of infringement because it's simply the wrong people because the IP addresses are reallocated versus a domain which has to be registered to an official person. Now, Is that person hard to find sometimes? Yeah, they can be hard to find. There's no doubt about that. We need to find ways to track them down. An IP address can be dynamically go to a different person every hour or every day. It's simply not consistent, again, with these intent of the bill to protect intellectual property. This bill is supposed to go after the worst of the worst, sites like Pirate Bay and others. This bill has provisions that allow orders to, or modified to go after websites, and even when websites change their name. But it's critical to ensure that we strike IP address from the form of definition of an internet website, because they are two different things. We need to go after the one that is connected to the infringer, not the one that could be dynamically generated and have different people at any point in time and could be used internally to control your own climate in your house or how well your toast is done. I urge you, yes, I yield to the gentlelady from California.
I would just like to commend the gentleman for the amendment, and this is actually something that we ought to adopt on a bipartisan basis. I don't know if every member of the committee, I'm not a nerd, I aspire to be a nerd, but through dynamic assignments of IP addresses, I mean, you can end up with, I mean, a multiplicity of potential devices or entities. And in fact, because mistakes have been made in the past, we've had lawsuits filed against a printer because the IP address was dynamic. And this is about the integrity of the infrastructure. Even though we disagree about many other elements of the bill, this should not be a source of disagreement. This is cleaning it up so that even though I disagree with many other elements of the bill, to fail to adopt this would actually defeat the intentions of the drafters of the manager's amendment. And I just wanted to make that point and thank the gentleman from Colorado for yielding, and I yield back to him.
I thank the gentlelady, and again, as the chair knows, I have some differences on the underlying bill, and one of them, of course, is the broad body of violators and the selective enforcement that would be necessary. This at least cuts down on that potential body of violators. It would prevent on some pretense going after almost anybody with IP addresses in their home that could at some point in time have been dynamically assigned to a website with a name who's registered with somebody, but at that time was used for illegal activity, but has been reassigned in a dynamic basis. So the website, again, something.com, something.net, registered to a person, there's ownership. We need to find those people. The IP address is not the right vehicle. It is dynamically reassigned, sometimes in real time, sometimes instantaneously. You can go through IP randomizers on the internet and have a random IP address assigned to you. And again, it is simply a mechanism for routing packets. It is not the name that is associated with a real-world person or entity that should be held legally responsible for piracy. And I'll yield back the balance.
If the gentleman
I yield my
further,
additional 30 seconds.
I think it's important to note, and I thank the gentleman for yielding, it wouldn't necessarily have to be skullduggery on the part of someone seeking to enforce. In fact, I think in most cases where enforcement actions have been taken against a toaster, it was a mistake, and for the reasons that you have well outlined, and I appreciate your technical expertise in bringing this amendment. I thank the gentleman for yielding.
And I yield back the balance of my time.
Thank you, Mr. Polis. The gentleman from Virginia, Mr. Goodlatte, is recognized.
Thank you, Mr. Chairman. Mr. Chairman, the gentleman's amendment strikes Internet Protocol or IP address from the definition of an Internet website. This is an important provision in the definition section of the bill. At times, websites operate using a fixed IP address and not a domain name. This carefully crafted definition ensures that these types of situations are covered as well. The amendment would create a loophole that criminal, foreign, rogue websites that are the target of this legislation that could be using this to exploit and evading the kind of efforts we are making here to cut down on the theft of American property and the defrauding of U.S. citizens. And so for that reason, I strongly oppose the amendment.
Thank you, Mr. Goodlatte. The question is on the amendment. All in favor say aye. Opposed, no. No. In the opinion of the chair, the noes have it.
Mr. Chair, on that I request a roll call.
Roll call vote has been requested, and the clerk will call the roll.
Mr. Smith?
No.
Mr. Smith votes no. Mr. Sensenbrenner? Mr. Sensenbrenner votes no. Mr. Coble? Mr. Gallagly? Mr. Gallagly votes no. Mr. Goodlatte? Mr. Goodlatte votes no. Mr. Lundgren? Mr. Shabbat? Mr. Shabbat votes no. Mr. Issa? Mr. Pence? Mr. Forbes? Mr. Forbes votes no. Mr. King? Mr. King votes no. Mr. Franks? Mr. Franks votes no. Mr. Gomert? Mr. Jordan? Mr. Poe? Mr. Poe votes no. Mr. Chaffetz? Mr. Chaffetz votes aye. Mr. Griffin? Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Gowdy votes no. Mr. Ross? Ms. Adams? Ms. Adams votes no. Mr. Quayle? Mr. Quayle votes no. Mr. Amade? Mr. Amade votes no. Mr. Conyers? Mr. Berman? Mr. Berman votes no. Mr. Nadler? Mr. Scott? Mr. Scott votes no. Mr. Watt?
No for a second time.
Mr. Watt votes no. Ms. Lofgren? Aye. Ms. Lofgren votes aye. Ms. Jackson Lee? Ms. Waters? Mr. Cohen? No. Mr. Cohen votes no. Mr. Johnson? Mr. Johnson votes no. Mr. Pierluisi? Mr. Quigley? Mr. Quigley votes no. Ms. Chu? Ms. Chu votes no. Mr. Deutsch? Mr. Deutsch votes no. Ms. Sanchez? Ms. Sanchez votes no. Mr. Polis?
Yes.
Mr. Polis votes yes.
Are there other members who wish to be recorded on the amendment? The gentlewoman from Texas, Ms. Jackson.
Ms. Jackson Lee votes aye.
The gentleman from Ohio.
Mr. Jordan votes no.
The gentleman from Arkansas.
Mr. Griffin votes no.
Gentleman from California.
Mr. Lundgren votes no.
Mr. Chairman.
The gentleman from New York.
No.
Mr. Nadler votes no.
Gentleman from California.
Mr. Issa votes no.
Clerk will report. Oh, the clerk will suspend.
One more.
The gentleman from Michigan.
No.
Mr. Conyers votes no.
The clerk will report. The gentleman from Pennsylvania.
Mr. Marino is recorded as no.
Clerk will report.
Mr. Chairman, 4 members voted aye, 29 members voted nay.
The majority having voted against the amendment is not agreed to. The gentleman from Ohio, Mr. Shabbat, is recognized.
Mr. Chairman, I have an amendment at the desk.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 3261, offered by Mr. Shabbat of Ohio. Page 18, line 4.
Mr. Chairman, I ask unanimous consent.
Without objection, the amendment will be considered as read, and the gentleman is recognized to explain his amendment.
Thank you, Mr. Chairman. This amendment addresses a technical issue that is unique to the obligations the bill would impose on payment network providers. The amendment would strike language in the manager's amendment that would require payment network providers such as MasterCard and Visa to take action in connection with individuals who have been issued a credit or debit card by a U.S. bank, but who, for one reason or another, reside outside the U.S. This change would clarify that the individual to whom the credit processor must take action must have a U.S.-issued account and must also currently reside in the U.S. The kind of situation we're talking about here is, for example, a U.S. diplomat on detail in one of our embassies, or a soldier, or a college student studying abroad for a semester. This is a small number relative to the total number of cardholders in the U.S., but still worth addressing. The procedures and systems the payment networks have in place to prevent cardholders located in the U.S. from purchasing infringing goods are not designed to address the purchase of infringing goods by persons who reside outside of the U.S. An entirely new system would be required to address these circumstances, which would take additional time, substantial resources, and could ultimately detract from our end goal.
Requiring these companies to develop new systems would be extremely onerous and would be insignificant to our overall objective of stemming the tide of infringement. Surely the burdens would outweigh the benefits. By removing this language, we are not diminishing the effectiveness in any way of the bill in preventing U.S.-directed sites from providing infringing goods or services to users located in the U.S. In short, the amendment allows payment network providers to protect the interests of U.S. rights holders through the systems they have in place today, and will ensure that payment networks can fulfill their obligations under the bill without the need to develop, build, and maintain new systems or technologies in order to comply with this legislation. And I yield back.
Would the gentleman yield to me before he yields
I'd
back?
be happy to yield, yes.
I thank the gentleman from Ohio. The gentleman's amendment conforms the obligations of payment network providers with the definition of a U.S.-directed site to target Internet sites providing goods or services to users located in the United States and that also have accounts originating in the United States. I believe this is a reasonable amendment, and I urge my colleagues to support it.
Now yield back.
Mr. Chairman?
The gentlewoman from California, Ms. Lofgren.
I'd move to strike the last word.
The gentlewoman is recognized for 5 minutes.
I'm trying to understand the impact of the amendment. I'm wondering if I could pose a couple of questions to the author. I live in San Jose, I have credit cards. If I go on a trip to Canada and I use my credit card in a way that would infringe, would I have a free pass under your amendment?
Well, gentlemen,
I would, because I'm trying
I don't think this would affect that at all. This talks about residing, so it wouldn't affect somebody who's just a tourist or something. It would only apply, you would have to talk to the chair about the rest of the bill, but this amendment would not apply to that.
So what would the definition be between residing and a temporary brief visit? Is that anywhere else in statute?
Well, the definition of reside, the legal definition of reside.
Will the gentlewoman yield?
I would. I mean, I'm not necessarily opposed to the amendment.
No,
I'm just trying to figure out how it would work.
I guess my question would
yes,
clarify.
I would yield.
Are we talking about Rahm Emanuel in Washington, D.C. residing, or more permanent?
I'll let the gentleman come to his own conclusion about that.
Very good, thank you.
Reclaiming my time, I'm trying to figure out also how this would work on, I mean, we're used to having, we have a credit card, it's in our wallet, but there are, for example, PayPal is a very large payment system that I believe is covered by the manager's amendment. How would your amendment interact with the PayPal system where the ascertainment of locale may be less certain than in the Visa, MasterCard world? If you could address that.
Yeah, the fundamental, if gentlelady will yield, the fundamental purpose of the bill is to deal with people in the U.S. market, not elsewhere. My amendment only deals with people who reside outside the U.S., and that's why I mentioned specifically a U.S. diplomat who's overseas.
No, I understand the intention. The question is, what does the actual language mean?
Yeah, the language means reside outside, not if you're just visiting or anything like that.
And would it be, for example, in immigration law, a brief a visit abroad doesn't interrupt residence, but that has to be a very brief period of time. Would that be the standard that you are thinking here, or would it be the tax standard?
If the gentleman will yield.
I would be happy to yield.
I have whatever the existing law would consider to be terminology for reside. And that's why in my statement I specifically mentioned, for example, a soldier, a college student.
Recalling my time, I understand what the intention is, but I'm trying to get to what the standard will actually, what a court would do. Because there are different standards in law. I mean, for tax purposes, there's one standard for reside. For immigration purposes, there's a different standard for reside. We recently adopted the bill having to do with taxation of income for employees between states. I don't know that that would necessarily apply. So I'm trying to get some insight into, I mean, I'm not saying this is a bad idea. I'm just trying to get some insight on what in existing law would be used as a benchmark for determining residence.
Yeah, if the gentlelady will yield.
I would be happy to yield.
Thank you. I appreciate that. The reside that I'm referring to would be the common legal parlance used relative to that term. One can never, in my view, predict what a court's ultimately going to do with that. I would have to perhaps defer to the chair to see if there is a definition in the bill itself or in the manager's amendment that specifically, is there a definitional term?
Well, recalling my time, there is no definition in the manager's amendment nor in SOPA.
Yeah. Then it would be one would use the same procedure here as they would in any other legal case when using a term. If it's not defined, then it would be defined as it's generally considered in the law in general.
Well, recalling my time, the problem I have with that is not the intention, because I think it's a reasonable intention, is that there's no real common law determination in the federal law. We have a multiplicity of different rules depending on the situation. I mean, there's one period for taxes, there's one period for immigration, there are other standards, and I think it would be helpful if we have something in mind to actually reference that in the amendment so that it's not anybody's guess, people know where they stand. I mean, I'm not in opposition to what you're trying to do, I'm just thinking that if this is somewhat uncertain and we don't want to leave it just to whatever a district court decides, it seems to me. First, I'd like to yield to the gentleman from Ohio.
If the gentlelady will yield, I would be happy to work with the gentlelady and in a definitional portion of this include it either in later on or at an appropriate time so that we specifically put the parameters of what reside means, and I'd be happy to do that. I'd have no objection to that, but I really don't want to get this out of order. I'll yield.
Gentleman's time has expired. I'd like to vote on this amendment very quickly, if we could. Then we're going to recess.
Mr. Chair, if I can just move to strike the last word.
Gentleman from Colorado is recognized.
And I don't think I'll need the full 5 minutes, but I just want to further engage with Mr. Shabbat. If I'm trying to understand this amendment here, you are replacing an or condition because you're then eliminating the word or, and you're qualifying customers located within the United States. So originally, we prevented the affiliation of payment networks to also accounts originating in the United States. Presumably some of those might be held by foreign nationals. I believe you're then changing customers located within the United States, again, replacing the or condition and saying customers within the United States who have accounts originated in the United States?
Correct.
Okay, I just wanted to clarify on that, and I'm happy to yield back the balance of my time.
Thank you.
Thank you, Mr. Polis. All in favor of the amendment say aye.
Aye.
Opposed, no. Amendment is agreed to. Without objection, the chair is authorized to declare recesses of the committee at any time, and I will now say we will recess until immediately after this series of votes. Do we know how many votes there are going to be? Four votes. There are 4 votes, so it will probably be about 45 minutes, and if members will return very quickly after the last vote, we will recess until then.